Hello, my name is Dr. Vishwas Devaya. I am an associate professor at Jindal Global Law School, Sonipat. Today we are going to focus on philosophical justifications of intellectual property rights. The presentation will be structured. Firstly, we will be discussing utilitarian theory. Secondly, we will be discussing about the Lockean labor theory, and thirdly, we will be looking at Hegel's personality theory. Before we actually begin with the utilitarian theory or utilitarian justification of intellectual property rights, it is important to raise certain questions. What are these questions? These are basically, should we actually treat intangible property rights like trademark, copyright and patent law as property rights? Why should they be granted protection at all? Are they equivalent to property rights? All of this, to find an answer for this, we'll actually basically have to look into the philosophical foundations of intellectual property rights. To do so, we will be basically looking at a number of theorists like John Stuart Mill, John Locke and Hegel, who actually came up with certain theories in a completely different era, but they were not necessarily forwarded with intellectual property in the mind as such. They were largely kind of foundations of philosophical visions presented by these various philosophers at various points in time, linking it to the political times in which they lived. But a lot of academics have actually utilized these philosophical theories espoused by them to justify intellectual property rights. So let's begin with the utilitarian theory of property. Firstly, let's begin with John Stuart Mill's justification of utilitarianism. John Stuart Mill was the person who espoused the utilitarian theory. Stuart Mill actually said, an act is said to be good if it results in the greatest good for the greatest number of people. Now, Mill was not the first person to actually talk in terms of consequentialism. It was basically Jeremy Bentham who actually kind of started with the utilitarian theory, but Stuart Mill actually kind of modified and said an act would always be good if it results in the greatest good of the greatest number of people. Now, how do you calculate whether a particular act is good? Now, Stuart Mill said you have to basically count the amount of happiness a particular act causes and the amount of harm a particular act causes. If you weigh the harm against the happiness, if the happiness outweighs the harm, then basically such an act would be a good act. But if the harm actually outweighs the happiness, then such an act should be discarded because it is a bad act as such. So, as far as Mill's utilitarian theory is concerned, if it results in the maximum happiness of the maximum number of people, then such an act would be good, right? Now, how can you actually use this theory to justify intellectual property rights? Now, Stuart Mill says maximum happiness of the maximum number of people. Now, if you look at intellectual property rights as such, if you look at patent, for instance, take patent as an example. Now, the patent system awards or grants what is called as monopoly to the inventor, and the inventor kind of enjoys a monopoly for a period of 20 years. How could this actually be good for the public? Now, utilitarians would actually say, let's look at a particular invention. Does it actually cause good or does it actually cause harm if we grant a patent? Now, utilitarians would say the end result of granting patents would be actually good for the society. Now, how will they calculate the happiness and harm, basically they look at what is the end effect of actually protecting new inventions. If new inventions are not protected at all, that is, if you do not grant any monopoly, then any person who actually comes up with a new innovation will basically not come forward to tell or announce in public that he has come up with a new invention. In fact, they largely kind of hide their innovations because they believe that they have put in the hard work to kind of come up with an invention, but it is largely the others who hear about the invention who would actually kind of replicate their innovations. That in the sense basically means if a person has invested a certain amount of time, money, labor in actually coming up with a new invention, a person who actually hears about that invention would actually replicate in a short period of time and possibly make profits. This would actually hinder a person who has come up with an innovation to come out with that information if there is no protection for his innovation. But if you look at the other way around, that is, if a patent is granted and monopoly right is given to the innovator, that basically means the innovator enjoys protection for a certain period of time wherein he can actually practice his innovation, wherein he can disclose how the innovation is created, and at the same time recoup the money or invested amount during the period of the monopoly as such. Right? So, Mill would in fact agree that patent monopolies would be appropriate because it actually rewards a person who has actually worked on a new innovation. If innovation is not protected, then the person would actually not come forward. That basically means the public would lose out on an innovation being made public, innovation being publicized. To give you an instance, a number of companies have secret formulas. Now, these secret formulas are basically secret because they think that the moment it is actually disclosed, and if there is no protection granted to the disclosure, then others would actually start to make these products and they would also be competing with them in the market, which may reduce their profit or the margins, etc. But if protection is granted, then a number of innovators could actually openly disclose these formulas, which can enable the public to learn about new innovation. It also allows downstream innovators to actually come up with modifications to a new technology as such. Right? So, in effect, the utilitarians would say granting patent monopoly is ultimately a win-win situation because it actually increases the greatest happiness of the greatest number of people. Similarly, the utilitarian theory can be used to justify trademarks as such. For instance, let's take the fact that there is no trademark protection. If there is no trademark protection at all, then people will actually be confused as to which product is sold by which manufacturer. Now, this is a fairly important aspect of consumption because consumers would generally like to kind of buy products which are safe, which are actually maintains a certain amount of quality. Now, if there are no marks on a particular product, then possibly the search costs, that is basically finding out which product is of a quality product, would actually take a lot of time for the consumers. This results in a wastage of time. This also results in a lot of wastage of money because consumers could also be deceived at any point in time if marks are not necessarily protected. But on the other hand, if marks are protected, say for instance a consumer goes into a store, he knows very clearly which product to buy because largely he relies on a particular mark being imposed on a particular product. He knows that this mark kind of symbolizes a certain quality and the very fact that it originates from a particular manufacturer. So, in effect, granting trademark protection would kind of largely help out consumers, would avoid search costs, would ensure that there is no deception, and from a manufacturer's perspective as well, it is a good kind of an incentive for the manufacturer to maintain the quality and ensure that his products throughout are of a particular quality, because the moment the consumer identifies the mark with a certain quality, he is likely to keep buying the same product time after time. A good example would be a person buying a Samsung phone, a person buying an iPhone for a particular reason, right? Because they understand that it is of a particular quality, that it serves a particular end. If mark is not protected, then possibly consumers would be confused as to what to buy in the market. Similarly, John Stuart Mill's utilitarian theory could also be used to justify copyright. Now, how can this be used to justify copyright? Basically, if a certain monopoly period is not allowed for the author of the book who has published a book, then others can actually replicate the book and actually earn revenue out of it. But if the author is granted a certain period of protection, then it will allow him to actually come forward with the work, publish the work, and also recoup the costs and earn royalties by sales of books. But if no protection is given, that basically means the author would hesitate to actually publicly disclose his work. This, in the end, would basically mean that there will be very little work that will be published and circulated because there is no protection to the author, right? So, Mill's utilitarian theory in effect kind of says protection to all the three different intellectual property rights would in the end result in maximum happiness for the maximum number of people.